Hi, everyone, and welcome back to ICDR Rules in Practice. I'm Tara Gopalan, Vice President of the International Center for Dispute Resolution, the international division of the American Arbitration Association. I'm speaking to you today from the AAA-ICDR Asia Case Management Center here in Singapore, and I'm delighted to kick off episode 2 titled Navigating First Steps, Setting the Foundation for Success. If this is your first time joining us, absolute pleasure to have you. And if you're a returning listener, thank you so much for making time for us again. Let me start with a quick snapshot of who we are and why the series matters. The AAA-ICDR is a not-for-profit organization founded nearly a century ago in 1926. Next year, we celebrate our 100th anniversary. Our headquarters are in New York, but we operate globally with offices across the United States, a subsidiary in India, and our Asia Case Management Center in Singapore. In 2024, we handled over 537,000 new filings, which makes us the largest ADR provider in the world. We had parties from 87 countries with representation across Asia, Europe, Africa, the Middle East, and the Americas. Now, if I had to tell you what sets us apart, I'd point to three things. First, efficiency and innovation. We're constantly rolling out new tools and procedures to make arbitration and mediation faster, more accessible, and more cost-effective. Second, we believe in collaborative dispute resolution. That's not just a philosophy, it's actually built into our rules, and you'll see that throughout today's session. And third, party autonomy really matters here. We give parties the room to shape their procedure, and we push our arbitrators and mediators to deliver outcomes that are not just enforceable, but fair. So if you're looking for a process that's efficient, flexible, and globally trusted, this is it. Let's take a quick look back at episode 1, where we opened the series with a session on arbitration clauses. We talked about what makes a clause work well under the ICDR rules, and what can go terribly wrong when it's over-engineered. We covered the ICDR model clause, best practices for multi-tier clauses, and also talked about why simplicity often wins when it comes to arbitration selection. If you missed the episode, check it out on YouTube. Now, on to episode 2. Today, we shift gears from clause drafting to what happens when the clause is triggered, when the real work begins. Our focus is on the first procedural decisions that shape an ICDR arbitration, what to consider before filing, how to prepare for emergency relief, how to think strategically about your notice of arbitration, and how to make the most of early-stage tools like the administrative conference. We'll talk about the procedural architecture of ICDR arbitrations and how it can help or hurt, depending on how you use it. We'll also walk through the trade-offs between national courts and emergency arbitration, how detailed your initial submissions really need to be, and the inner workings of the ICDR arbitrator appointment process, particularly our unique list method, which often surprises users coming from other institutions. And I'm thrilled to be joined today by a panel that knows these rules inside out. Zeslyn Mao, who's moderating today's session, is counsel at WilmerHale. She's qualified in both Singapore and New York, fluent in Mandarin, and brings a rare combination of courtroom, tribunal, and judicial experience. Hiroyuki Tezuka is a leading figure in the international disputes world, especially in Japan. He heads the international dispute resolution practice at Nishimura and Asahi. We are also really lucky that he serves on the ICDR International Panel and the ICDR Asia Advisory Council, and clearly brings sharp comparative insights from decades of cross-border experience. Wen Dai is a partner at Zonglun Law Firm, one of China's largest law firms. She has acted in, administered, and decided hundreds of arbitrations. She's on the ICDR She brings practical insight from both the PRC and global practice, and is someone who served as an emergency arbitrator herself. She knows the nuances of urgent relief better than most. And last but certainly not least, Dr. Kabir Dugal, who really needs no introduction. But I proceed nonetheless. He's a council member of the AAA-ICDR, senior international arbitrator advisor at Arnold & Porter, lecturer at Columbia Law School, an arbitrator, mediator, educator, and one of the most prolific arbitration thought leaders in the field. We're also really lucky to have him on the ICDR International panel. And so, Zeslin, without further ado, over to you.
Thank you so much, Tara, for that amazing introduction. Kicking off the discussion today, we wanted to begin by talking about what parties should consider before commencing an ICDR arbitration. And if we can have the slides up, just to highlight two interesting aspects of the ICDR rules that parties may want to bear in mind before commencing an ICDR arbitration. So the first is the International Expedited Procedures. That would be in Article 414 of the ICDR rules. And we are just putting, for today, some key points up that we will be discussing. But if for the audience, if you would like to follow along, the ICDR rules are available online, and I believe a link will be sent in the chat shortly. So just back to Article 1.4, these are the international expedited procedures, which apply when no claim or counterclaim exceeds $500,000 US. As the name suggests, the timelines in an expedited case under the ICDR rules are very quick. Parties may agree to use these procedures in other cases as well. And that could be, for instance, where perhaps no monetary damages are being sought. Where the claims do not exceed US dollars 100,000, these shall be by default resolved by written submissions only unless the arbitrator determines an oral hearing is necessary. The second rule I wanted to highlight at the beginning is Article 6, so that's the next slide, that provides that by default, the parties shall mediate their dispute concurrently with an arbitration. This is quite an interesting aspect of the ICDR rules that perhaps we don't see in many other international arbitration institutions. So with these 2 points in mind, I would like to now turn to the panelists and ask each of them to share one point which a party should consider before commencing an arbitration. And perhaps we can start with Tezuka Sensei.
Thank you, Zeslin, for a kind introduction. And just one thing about the APP. I know that some other international arbitral institutions have tried to expand the application of APP by raising the claim amount threshold eligible for APP. For example, SIC in Singapore has raised it from 6 million Singapore dollars to 10 million. So it can include a big case. But I have heard some concerns from some Japanese users that there may be cases in which the claim amount is below that threshold, but the case is complex enough, and particularly where the governing law is Japanese law, they are concerned that the sole arbitrator, who may not be a Japanese law expert, may have some difficulties. So I think you should consider whether you should opt in or opt out, and how to structure a claim in light of the manner in which your claim will be quantified for purposes of the application of APP. And I know that ICDR's threshold remains to be relatively low. Okay, that's my first point. Thank you.
Thanks so much, Tezuka Sensei. And perhaps we can get Dr. Dugal to go for it next.
Sure. I mean, I'm delighted to be here. Very grateful to the ICDR, very grateful to Zeslin for her amazing moderation, and to 79 of you who have shown up. This is one of the beautiful things about Asia. I think the commitment and passion for arbitration is really deep. Let me just make two very quick points. I see my friend Wendy. Wendy is back, so I'll just do this quickly and allow the discussions to go on. The first point, whenever you're thinking about a dispute, commencing a dispute, is just really to know the dispute, to get in it with your uh, case strategy, with your preliminary thoughts on the case figured out. Just the second point, and this is something that Tara in her remarks had outlined, the ICDR rules really give us a very flexible, collaborative approach to dispute resolution. You will see this pretty much in every article in the ICDR rules, unless the parties agree otherwise, and then they'll give you a default mechanism. And this is something you really want to pay some attention to, because there is this procedural flexibility, and you really want to see what makes most sense for you when you are in a dispute. What are the party expectations? How would this procedural flexibility play out in an international dispute, right? The rules tell you what the rules tell you. The tribunal that is going to be constituted, and we're going to talk about this in some detail shortly, may have some expectations based on where they come from, right? A civil lawyer may look at things differently from a common lawyer. We are all products of our training. And this is something you may just wish to consider. How would the rules get operationalized? But with that, Zeslin, I'm going to stop here and pass the mic back to you.
Thank you, Kavya. So we have Tezuka Sensei said we should think about the emergency arbitrator rules, emergency procedures. Kavya mentioned we should keep in mind the flexibility that ICDR rules affords. Next, I want to turn it to Wen to share her thoughts about what are the initial considerations she feels should be considered before commencing an arbitration. Wen?
I think she may have bad internet. We may just want to give it a few minutes. We could continue and perhaps come back to Vendai once her internet's a bit better, if you agree, Zeslin.
Yes, I think so. I wasn't sure if we could hear. Okay, no worries. Let's move on for the time being as Wen sorts out her internet. Wanted to really move next to the phase of the dispute where interim relief may need to be sought on an urgent basis. And here we wanted to flesh out our summary of Article 7 of the ICDR rules. If we could put that on the screen. That is the rule that allows a party to apply for emergency measures of protection before the constitution of a tribunal. And 3 points we wanted to highlight for Article 7. First, the application shall be submitted concurrent with or following the submission of a notice of arbitration. It should include a statement certifying that all parties have been notified, or an explanation of the steps taken in good faith to notify all parties. So it's not envisaged that it would be an ex parte application. And finally, the power of the emergency arbitrator is to order or award any interim or conservatory measures that the arbitrator deems necessary, including injunctive relief or measures for the protection or conservation of property. And here I would like to invite Kavya and Tezuka Sensei to pitch in with their thoughts on the strategic considerations parties should bear in mind when deciding whether to obtain emergency relief in the ICDR before a tribunal generally, because one of the big considerations that presents itself at an urgent relief stage is whether you should go before a tribunal or before a national court. And so with that, I'll hand the floor to Kavya.
Thank you very much, Zeslin. And just before we start, a little shout out to the ICDR here. because the ICDR was the first institution to have conceptualized and framed emergency protection in its rules. Today, we would consider this to be pretty consistent across all the institutions, but it is the ICDR that had really conceptualized it. Now, let me illustrate on the point that you presented, right? The choice between courts and a tribunal. What may you wish to think about? And Zeslin, to do this, with your indulgence, I'm going to enact a scene where Kabir from New York is in a dispute with Zeslin from London, and our seat for arbitration is Paris. Okay? So New York, London, seat in Paris, something that you do see happening in a dispute. Now, in this particular scenario, right, if I want emergency relief, the arbitral process puts a preference or a priority on going to the seat. So the arbitration philosophy generally is we go to Paris to get relief to assist with the arbitral process. But the problem that happens is if the relief I need against you, Zeslin, you being based in London, going to a Paris court is not really going to help me in many meaningful manners. Your assets may not be in Paris, right? This was the first problem that came up. The seat may really have very limited reach if your assets are not in the seat and you're seeking emergency relief because it is really super, super urgent. Now, the second choice is, I go to the jurisdiction where the respondent is based. Now, in my example, it's London. London is probably an outlier example, like Singapore or some of the very popular arbitration places. But, there is very genuine concerns that, suing a defendant, suing a respondent in their home territory may not give you real justice, right? It may be a perception problem, but a perception problem is a reality. And this is why the ICDR really said there is a need for us to give a mechanism. And the reality was you didn't have a mechanism to allow a party to seek emergency relief before a tribunal. That's how this was conceptualized, a very practical arbitration solution to a problem. Now, where would you want to go? Like anything in life, you have to weigh the pros and cons. You have to make an informed decision. But having a mechanism within the arbitration does allow us to seek relief within the process. It is again something that if a party doesn't comply with the decision, remains within the record, right? Don't fight with your decision maker. So the mechanism for me and the one that the ICDR offers us is a good one. With that, Zeslin, I am abusing my time. I'm going to stop and pass the mic back to you.
Thanks, Kavya. So that's actually very interesting because, as you say, sometimes the national court may not, the seat court may not actually be the most ideal place to seek emergency relief. And I guess a large part will also depend on the enforceability of the emergency arbitration award in the place where you want it enforced. And that's a point I think Tezuka Sensei, you will share with us right now.
Oh, thank you. So as you may know, the 2006 amendment to the ancestral model law has introduced the enforceability of the arbitral tribunal's interim measures. And Japan has adopted that concept just 2024. And in adopting the 2006 version of the model law, depending upon the jurisdiction, for example, in Korea, they say that enforceability is given only to an interim relief issued by a tribunal seated in Korea. But in Japan, we don't have such restriction. So you need to check what position the jurisdiction which is relevant in enforcing the tribunal's interim relief takes. And as to the emergency relief, my understanding is that not many jurisdictions would recognize the enforceability of such measures, but still there can be some issues, particularly where the seat of the arbitration says that the emergency relief shall have the same effect as the arbitral award. So it's a complicated issue. And talking about the difference between the national court and emergency relief, of course, tribunal's jurisdiction would normally not cover the non-signatory or third party. So that could be a difference. And the language is different. And also the availability of the remote hearing could be different depending upon the states. The Japanese court takes a very conservative view, so there would not be any cross-border online hearing. But lastly, I would say that in Japan, the court has the power to issue a very strong preliminary injunction, depending upon the size of the claim or the value of the asset. The size of the security money could be very, very substantial. Thank you.
Thank you so much, Tezuka Sensei. So that's actually really interesting. This whole idea of enforceability of the emergency arbitration award seems to be quite a minefield, and every jurisdiction has its own rules, and it may in fact not be enforceable in some places either. So that's something very important to keep in mind when looking for emergency relief. Finally, to take matters to a more practical perspective, we would like to ask Wen. So as Tara introduced her previously, Wen actually sat as an emergency arbitrator on the first CTEC emergency arbitration application in China, so has deep experience hearing emergency arbitration applications. So with her experience, we would like to ask her to share what are some of the do's and don'ts for successful emergency arbitration, keeping in mind the ICDR rules. Wen, please.
Yes, thank you very much, Zesla, and also Tara's very kind introduction. I think from my perspective, first, I would like to say, in my view, EA is a mini arbitration. I mean, not like the ex parte procedure before court. In some jurisdictions, when we talk about the interim relief, in the EA proceeding, both claimants and respondent will participate. And in many, many cases, if not all, there will be an oral hearing. So the parties, first, you should bear in mind, you need to prepare everything that there will be a proceeding, both parties participate. And second is that you must have a very accurate understanding of the specific EA rules that apply to this EA proceeding. I believe that we have already mentioned that ICDR is the first ever arbitration institution that create this EA practice. And following this ICDR's innovation, nowadays you can see almost every major arbitration institution, they have their own set of EA rules. And if you give a closer look to these rules, you can see there are a lot of differences. So you need to have an accurate understanding of the specific rules that apply to your EA proceeding. For example, in ICDR, Zesla just mentioned, and also Javier mentioned that in ICDR, the starting point for EA proceeding is that you commence the EA when you commence the arbitration. So not earlier, but maybe you can later, right? So that's the second one. And the third one is that you need to prepare all the submissions very concisely and clearly, because in the EA proceeding, the EA need to make the decision in a very short time. So a very good quality of submission can help that EA to do a good decision in a timely manner. And the last point, which I think is the most interesting or the most charming character of EA, is that based on my personal experience in CTEC, where I sat as the EA arbitrator in that case, the parties even settle on the EA relief itself, which I try to find in other institutions' case reports. And I also realize that in some other institutions, in some EA cases, parties even settle the dispute itself in the EA proceeding. So maybe when the party decide whether to try court or try arbitration to do this interim relief request, party can bear that in mind. There may be a possibility in arbitration that party may settle that at the very early stage. Yeah.
Thank you, Wen. That's actually really interesting and a real motivator for the lawyers who have to work on an urgent basis for any emergency application. You can take heart that your work may contribute to a settlement of dispute for your client. Yes.
Yeah.
I just wanted to, for the audience, raise a point that we do have a Q&A function in the Zoom chat. So if anyone at any time has any questions, do feel free to pop it into the Q&A, and we'll try to take it as we go along or at the end of the session as well. So that brings an end to our discussion on emergency arbitration, which can merit a full conference in and of itself. But we very quickly would like to move to the next stage of the arbitration, which is the filing of the initial arbitration documents. And here, two rules or two articles of the ICDR rules are relevant. And if we can have them on the screen shortly. First would be Article 2.3, which sets out what should be contained within a notice of arbitration under the ICDR rules. And do note that for ICDR, there's actually a standard form available on the website, which parties can fill in that sets out, all the matters that need to be included in the notice of arbitration. So the main things here, which we usually see as well, would be the identity and contact information of parties, a copy of the arbitration clause, a reference to the matrix contract, a description of the claims and facts supporting it, and a relief or remedy sought, including the amount claimed. Optionally, for ICDR, you could include a proposal as to arbitrators, seat language, and willingness to mediate, bearing in mind Article 6 that we previously looked at. Moving to the answer, which is in Article 3.2, so that's the next slide. That we've just set out the rule here. It states that when the respondent submits an answer, which is due 30 days after the notice of arbitration, the respondents may make any counterclaims or assert any sets off in the answer, which is a point perhaps to take into account for defendants. Our bench today, as we've heard, has very deep expertise in conducting arbitration seated in different jurisdictions with different parties. So I wanted to start by exploring another practical issue that many lawyers and parties would be thinking about, which is really how much detail should one include in a notice of arbitration and answer. The received wisdom generally is that notice of arbitration, don't put too much detail, and usually we would not file witness statements or expert evidence on that. So to start off with, Wen, I wanted to get your views on the pros and cons of this default approach, and in your experience, are there cases which would merit a more detailed notice of arbitration or answer?
Yes, I think it's a very important and practical question. I mean, a level of detail can have a significant impact to the arbitration proceeding itself. So from my perspective, I think a bare bone approach to notice of arbitration and answer has its own advantage and disadvantage. For the advantage, I think it's very cost effective and also very efficient. You can start the arbitration very quickly. And also that you can have the flexibility to set up your case strategy at a later stage when more information are available. However, it apparently has risk because a lack of detail may create misunderstanding of the case and also create some difficulties for the arbitration institution or maybe tribunal to make decision on some preliminary matters. So nowadays, I can see more and more cases, especially the dispute amount are very large, very complicated cases. Counsels and parties prefer to submit a more kind of a detailed notice of arbitration and also the answer. So I think the best practice is striking a balance between the bare bones dodge, this brevity and the clarity. You need to submit your submission very concise, clear, but also provide the tribunal, the institution, enough detail for them to have a accurate understanding of the case at the very beginning. Yes.
Thank you, Wen. And Tezuka Sensei, perhaps we could also get your views on the pros and cons of how about you? What do you think about whether it should be more detailed or less detailed in your experience?
I would rather talk about what you should expect. Both have pros and cons, but one important point with the ICDR arbitrator selection is that depending upon the arbitration clause and the actual arbitration selection process, it may be the case that arbitrators, particularly the chair, may have a very strong domestic backgrounds, and I would say that there can be a common law flavored international style and civil law flavored international style, but U.S. domestic arbitration style is entirely different in that it normally comes with a very thin notice pleading with the expectation that very broad document discovery is coming so that the parties will know what are the disputed issues. So it is entirely different from the more global practice of having at least one exchange of substantive submissions. Typically, the first round of submission, statement of claim and statement of defense. And then you would know what kind of document the other party submit and what could be the issue. And then there is a more limited document disclosure. So the point is, what kind of style you should expect, and coupled with the unique feature of the AAA ICDR arbitration selection practice, where it can be the case that the arbitrator selection comes much later than the exchange of the notice of arbitration and the answer. So in many cases in ICC, SIC, the claimant would select its own nominee at the time the notice of arbitration is filed. So you could know that at least one, for example, one civil law arbitrator will be there. But in ICDR, you may see that the strong domestic background arbitrators are the majority, for example. So my point is that you should be ready for such situations, which may be a little bit different from what you could expect under some other major institutions.
That's actually a really important strategic consideration, Tezuka Sensei, because what you're saying is that you're looking far down the road of the arbitration process, and at the point of filing the notice of arbitration, you actually don't know who your arbitrator might be and what style they might prefer, but you need to consider who they might be potentially, and perhaps think about that when doing the notice of arbitration so that they will have the best kind of understanding of your dispute.
Yes.
Yes. Thank you so much.
It's a subtle practice.
Exactly. Now I would like to turn to Kabir. And to start us off with perhaps your thoughts on this particular question. And then after that, I have a more specific question for you about Article 3.2.
Sure, sounds good. Let me just begin. Both my amazing co-panelists have made very valid points, and I fully agree with them. The ICDR rules require us to give what in the US we have just heard Tezuka Sensei mention. It's a notice pleading. And a notice pleading is really doing exactly what the name tells us. It is putting the opposite party at a very high level on notice about what your claims are. But you're doing it at a macro high level. There's breach of contract, breach of tort. I envision damages are going to be in this range, and that's kind of what you're doing. You look at the forms that Tara kindly posted and you see them. They're really simple, really streamlined. You can actually complete the notice of arbitration like in 15 to 20 minutes. Super efficient. I think the best practice, and this gets to Wendy's point, the best practice seems to be to fill this form and often put a 2 to 5 pages accompanying document where you spell out your case again at a very high level, but in some amount of detail. And I think this is really an efficient process. If we believe that the goal is not to make the process very expensive, you're going to have your opportunity to make your statement of claim. Right? Spell it out then. So I think this is a good compromise where we have come to. The rules have efficiency embodied in them, and we see that reflected in practice. Now, I know you have another question, so let me pause here and pass the mic back to you, Jaslyn.
Thanks, Kabir.
Sure.
Yeah, I guess I mean, in terms of this point, as you say, sometimes I guess a claimant may want to be cheeky and just put a lot of pressure on the respondent as well by filing a really detailed notice of arbitration with witness statements.
Yep.
And in that case, with the flexibility of the rules, it may well be a situation where the tribunal's looking at it, coming to it, says, okay, let me then actually start with the respondent by you filing the response to, instead of the usual statement of claim and then response process. So that could be one. But I mean, we don't see that often. So yes, I yeah, go ahead.
No, just the point you're making is a very valid point. The arbitral process moves on the assumption parties are going to act in good faith, but parties can weaponize anything, right? And this is just a claimant by virtue of being the claimant can weaponize the process to the extent that you decide when you're going to file. And once you file, the institutional rules will trigger timelines. And you can, just as you said, weaponize the process by putting in 100-page, very detailed expert opinions, witness statements, and really put the respondent in a tough spot. Now, I think this is going to lead beautifully to where you, I think, are headed, but let me pass the mic back to you for you to ask it, and then we have the discussion.
Yes, exactly. So I don't know if the audience recalls, well, if we recall Article 3.2, which is about the answer, it states that the respondent may make any counterclaims covered by the agreement to arbitrate or assert any set-offs. So first point is that it's interesting that it actually mentions set-off, which we don't see often in other arbitral institution rules. And the second is the use of the word may. So my question is, could you give us your views, Kabir, being counsel and arbitrator on many ICDR arbitrations, whether a respondent must include any counterclaim or set off in an answer? And if the respondent chooses not to do so, is there a risk that they may be prevented later from asserting a counterclaim or a set off?
This is a great question, and again, you will see how the ICDR rules really have flexibility inbuilt in how the rules are constructed. Now, if you look at the form that Tara kindly posted in the chat, you will see that the rules do require you the respondent, to outline your counterclaims. That is the whole point of a notice pleading. One party is telling the other party what the claims are, the other party is telling the claimant what their counterclaims are, right? So you're trying to put each other on notice. This is what the general expectation is. Getting back to your earlier point, Zeslin, you know, rules can be weaponized. Rules can just be, a party may not be ready. A party may not know, right? If you're the respondent, 30 days can move very quickly, right? You have to find counsel, you have to get counsel up to speed. They may have to read all the documents. That's where Article 10 of the ICDR rules come into play, because the ICDR rules there kind of give you a slight safety valve, telling that tribunal, you can allow claims or counterclaims to be modified, and then it'll tell you best practices again. It should be something genuine, it should not be prejudicing the other party, it should not be something that you were just sitting on your southern end not paying any attention, right? You have to have acted diligently. But the rules do allow you this possibility that even if the deadlines are the deadlines have passed, the deadlines have elapsed, you still have this mechanism to try and convince the tribunal to do justice. Again, a great example of the flexibility that the ICDR offers us. Thank you, Jess.
Amazing. Thank you. That's amazing and really important to bear in mind. And I think the ICDR rules also does have the philosophy of trying to have everything perhaps on a notice basis coming in. So that ties in with the philosophy of also mediating concurrently with everything before both parties. They can then perhaps take that into account in resolving their dispute. Finally, we come to a very exciting part of the ICDR process, which again, I believe is unique to the ICDR, and that is the administrative conference that is held after the notice of arbitration is filed. So if we can just flash up Article 4 of the ICDR rules on the screen. This rule basically states that an administrator may conduct an administrative conference before the tribunal is constituted to facilitate party discussion and agreement on issues such as arbitrator selection, mediating the dispute, process efficiencies, and other administrative matters. And in practice, this is usually held after the notice of arbitration is filed, and in fact, before the answer is filed. Kabir, again, back to you. You've sat on, many ICDR arbitrations. Could you give us your sense of how the administrative conference helps make an ICDR arbitration more efficient, or what role does it play in that process?
Fantastic, Zeslin. Thank you. I mean, this for me is one of the big selling points of the ICDR. And from an arbitrator's perspective, and you will notice Article 4 uses the word may. Now, the word may is not the institution. The institution will always propose an administrative conference, but it's the parties. Do the parties want it or the parties don't want it? Right? And often, if the respondent isn't participating, if they're not ready, that's where you see problems coming up. But the ICDR will always insist on having a call in spirit. It'll be brought to the attention. And if you have a call, it is going to make the arbitral process so much more streamlined. Right? You can get both parties, you can figure out things like, are there preconditions? Would you like to mediate? I saw a question, and I just direct everyone to look at the ICDR rules. They actually begin with about 10 or so odd number provisions on mediation. So just take a look at them, because there is a very beautiful philosophy that the ICDR has when it comes to mediation, which can move in parallel with the arbitration. Absolutely brilliant. But matters like this, can you have any specific requirements you want your arbitrators to have, right? I need my arbitrator to be admitted in Japan, to be fluent in Mandarin, right? Sometimes your clause may not have them, but the parties may jointly agree on this. It just makes the process so much better, because otherwise you're going to go to the preliminary conference right? The arbitrator, and all sorts of objections are going to come up. You can avoid all that when you tell it to the institution, and the institution will try to accommodate them and try to do everything to make sure that the party's process is respected. So highly recommend it. And with that, I'm going to pass the mic back to you.
Amazing. And as you said, I think it is a unique aspect of the ICDR rules, or feature of the ICDR rules, that you really get to talk directly and have a meeting with the administrator about the arbitrator selection process. And as you say, you can say, oh, I would like a Japanese arbitrator or a civil law arbitrator for this dispute. So that's very interesting. And in fact, that's the next point that we will cover, which is Article 13.6 of the rules, if we can again flash it up on the screen. So this is a very interesting opportunity that parties have within the ICDR to actually talk to the ICDR and tell them what they would prefer on arbitrator selection. And again, this is, I guess, one of the key features of arbitration as compared to litigation, which is that parties get to have input on the adjudicator that will be hearing their dispute. And the ICDR, in fact, has detailed rules on the arbitrator selection process. So by default, if there is no other agreed rule, what 13.6 provides is that an identical list of arbitrator candidates will be sent to both parties. Parties may either agree on an arbitrator from the list and inform the administrator. In usual cases, probably there's no agreement. And what each party would then do is it has some time to rank its preferences. It will be given an option to strike names. Usually it's about 10 to 15 arbitrators on the list, and you can strike 2 names for any reason. You then return the list to the ICDR. You don't exchange it with the other side, so you don't know who the other side have struck out. The administrator then looks at both lists and appoints based on rankings. And if there's no agreement or availability, the administrator can then proceed to appoint directly without new lists. This is quite an interesting process for arbitrator selection. And I would like now to invite Tezuka Sensei to share his views on what he thinks about this interesting process.
Oh, thank you. It's really interesting. And in one of my arbitrator cases, the ICDR selected 3 arbitrators for a case involving a Japanese party. And interestingly, the 3 arbitrators are selected, and the 3 of us had to nominate the chair, and we selected the most senior person who said that he has chaired over 200 cases. But we discovered that he is deeply, US style background oriented. So that could happen. And in other institutions where each party nominates 1 each, you may try to see who is the claimant nominee, and then you would somehow match the claimant's selection. And in the JCAA, the Japanese Arbitration Center, they have a unique style. That is, the selection of the party nominee should come at the same time. So you need to think about, what kind of arbitrator the other side will nominate. So it's a kind of a game. So rather than talking about the pros and cons, I just wanted to emphasize the importance of understanding the rules and the practices and what could happen, particularly where you don't have the arbitrator selection process agreed in the arbitration clause. And then once it is a case that there is a list, maybe you should think about how you could use your entitlement to drop off two people. Maybe you want to kick out someone who has a conflict, but you may kick off two people, and then you could also say that another two people would have conflict of interest, so you can kick off essentially four. So you need to be flexible, yes.
It's also interesting that this arbitration selection is discussed with the ICDR rules after the notice of arbitration is filed and before the answer is filed. So could there actually be a possibility where even though the contract does actually set out, a mode of arbitrator selection, for instance, claimant selects one, respondent selects one, and then the co-arbitrators select the president. It could be a situation where parties, look at 13.6 and think, oh, this seems like an interesting process to select the presiding arbitrator. And instead of what we have in our contract, I would like to actually agree on using 13.6 to select the presiding arbitrator. Do you think that's a possibility, Tezuka-sensei?
Yes. So I think ICDR's arbitrator selection process is fairly, unique and very flexible. So depending upon the case, you can be as creative as you wish. Yes.
Yeah, which is sometimes I think maybe useful because often, it seems to be a question whether the co-arbitrators can talk to the parties when selecting the presiding arbitrator, right? And I wondered, Kabir and Wen, whether you had any thoughts as well on this arbitrator selection process.
Just two very quick reactions. Point number one, this is a very thoughtful process because, to get on the list for the ICDR, you are vetted, you are trained, you have to do an annual requirement. So you're really getting people who have done some amount of academic as well as practical work, have been vetted. And that is a big advantage that the ICDR offers you. You're really getting competent people both academically and practically. And just a second point, this may be something a lot of people are not aware of. The AAA ICDR has a very unique a la carte service. And that is, even if you don't have the AAA ICDR administer your entire case, you can ask the AAA ICDR for a nominal fee to appoint your arbitrator. And they will use the list method. And this is brilliant, right? Because you have this great pool of arbitrators from all around the world. All of them have been trained, all of them have this competence and experience. And you can really ask them to draw on this expertise and give you a qualified panel. So this is something I would just shout out. Don't just think that the AAA only administers its cases. It really does offer you these bespoke services that can be very valuable.
Wow, that's amazing. And I think something for our audience really to take note. Wen, how about your thoughts on the arbitrator selection process?
Well, I think we always say that a good arbitrator makes good arbitration, right? So arbitrators selection is very important. And since my background is the Chinese mainland legal background, so in China, in mainland, that we care the arbitrator selection is very important. And nowadays, I can see, at least in mainland, the counsel is very creative. Sometimes that we just follow the rules. However, sometimes we see counsels, when they draft the arbitration clause, they make their own mechanism to choose the arbitrator. Sometimes it's two parties to discuss, sometimes two co-arbitrators to discuss. Sometimes they say that they ask the institution to provide a short list, and then we number the priority and then to find someone in common. So it's a creative process. And also to sometimes we see different institutions when they do nominations. They all have different styles. So again, that I echo Tezuka's saying that it's very important for you to understand the institutional rules and their practice.
Thanks very much, Ruan. So I think we've come almost to the end of our 1 hour discussion. I think we've really covered a range of topics, and it's been, wide ranging from the initial considerations before an arbitration, emergency arbitration process, filing of the initial documents for arbitration, and also coming to even arbitrator selection and this unique ICDR administration conference procedure. So I would like to ask Wen, bearing all these in mind and taking into account the unique ICDR processes, what perhaps you can help us to wrap up today's session by giving the audience, a couple of tips for parties in the first phase of an arbitration to really set the foundation for a successful proceeding.
Yeah, thank you very much, Tesla, for this question. Again, arbitration rules. I mean, for the counsels and parties, when you have dispute, the first thing you need to go back to the contract and see the dispute resolution clause, right? Where I should resolve this dispute. And then you realize it may be an ICDR arbitration or an ICC or CTEC arbitration, and then go to that rules to follow the rules, including that the deadline for the submission, and also the style, the requirements of the request of arbitration, also the answers, the procedure for the interim measures, or also jurisdictional challenges, etc. I mean, following these rules can help you to build up the credibility before the tribunal and before the institution, which can make sure the smooth progression. So I think that correct understanding, accurate understanding of the arbitration rules is very important. And here, since we are in the ICDR seminar, I would like to highlight, and also personally, I feel it's very eye-catching numbers in ICDR, is that I note there are statistics in 2024 in ICDR for the dispute where the claims dispute amount below $1 million. So if the case is not big, it's kind of a medium or small cases. And in ICDR, if party can settle in the arbitration, then the median time for that settlement is 6.5 months. And if party cannot settle, they proceed until the very last award, then the median time for them to get an ICDR award is only 10 months. And for the cost, if party can settle in that arbitration, the tribunal's fee is only $3,570. And if that is a standard arbitration, you get an award, tribunal's fees is quite competitive, is only $8,100. Why I raise that number? Because personally, I also act as arbitrator in CTEC, in Hong Kong IAC, and also sometimes in ICC. And I think the time the time is really fast. The cost is very low. So I don't know whether the audience, you may be familiar with these numbers, but for me, I think it's very eye-catching. Yeah. So I would like to share it by the end of this seminar. And on the top of the top, I think parties, you need to engage the professional counsel to make everything work. Yes. Thank you. That's all.
Amazing. Thank you so much, Wen. That's a really good point to close, which is to advocate for ICDR. I think everything ties in together, the flexibility of the rules, the how much the institution actually participates in moving the dispute along. I think all contributes to these eye-catching numbers, as you've mentioned, to create a really efficient process for parties. And yeah, I think Asian parties can really consider ICDR as a potential option for future arbitrations as well. So with that, we've come to the 1 hour mark. It's been an amazing session. And I really want to thank the ICDR for organizing this, to our great panelists, Tezuka Sensei, Dr. Dugal, Wendai, for all the great insights and contributions you have made. And finally, to our audience for really participating, asking questions, which I hope we've answered along the way. and also taking the time out to really attend this. So this is the second episode for this webinar series, and we'll have the third episode on even more ICDR rules down the line. So do watch out for that. Thank you very much, everyone.
Thanks, everybody. Have a good day.